Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, November 20th, 2024. We have an exciting show for you today with a couple repeat players. I am very happy to have them back on Short Circuit. So first of all, we have an Institute for Justice attorney. He's the managing attorney of our Texas office. He is our Texas boss, and that is Arif Panju. So Arif, welcome back.
It's great to be back.
Thank you. And Arif, as is expected, has a nice Fifth Circuit case coming your way in a little bit about some wild stuff going down in Texas. But first, we're going to have a real lawyer, as my mother would call him. No, actually, she's very proud, but I'm sure there are some public interest mothers who might say that, mothers of public interest attorneys, and that is Joe Diedrich. So Joe came on about a year ago for an episode, and he talked about a Seventh Circuit case, I believe, at that time. And now he's back with his own Seventh Circuit case. It is a very Seventh Circuit-y en banc opinion, and it is now perhaps going to the Supreme Court because he and his colleagues have recently filed a cert petition. We're going to talk about a couple other things to do with Joe's practice. Joe is an attorney in Madison, Wisconsin, a place I called home for a brief time at one time. And so we'll be hearing from him in just a moment. But first, I just want to welcome him. Joe, welcome back.
Anthony, it's great to be back. Always glad to be here.
So first we have a few updates. So we started doing this a few episodes ago to update listeners on cases we've talked about and like what happened to them, which we've done a bad job of, I think, over the years on this show. So we're trying to make amends. So we're not going to update every case. Like if a case just stopped and was remanded and that was it, we're not going to update about that. If no one appealed and the case was over, we're not going to update about that. But something notable, we will. So a few months ago, we had my old summer clerk, James Dickey, when he was a wee law student. He's now a big shot lawyer at the Upper Midwest Law Center. And he had a First Amendment case he talked about against a Minnesota school district. So that was in Short Circuit 332. And that case, the school district asked for en banc with the Eighth Circuit. It was denied, and they never filed the cert petition. So that case, I believe it's remanded, but perhaps the case is effectively over at this point. I don't know about that. But that's what happened there. Another one that from about the same time period that listeners may remember, Short Circuit 335, was we did a zoning special with my colleagues Ari and Joe, and they discussed a case at the Montana Supreme Court where there was a challenge to the state's recent zoning reforms that allowed people to build more housing, and somehow this wily opinion in a state trial court had said that allowing people to build more housing denied people their property rights. Didn't make a lot of sense. It was appealed, and without really reaching the merits, the Montana Supreme Court has reversed the preliminary injunction kind of on non-merits grounds. But the long and the short of it is the law can now go into effect in Montana and people can start building more housing. It's remanded to the trial court, and who knows what will happen after that. But that's that case. And then finally, in Short Circuit 339 at the end of the summer, we had our friend Anya on, but also JT Morris of Fire. And I've already updated people about his case, Villarreal, which we've talked about many times on Short Circuit, and that it was GVR'd at granted, vacated, and remanded at the Supreme Court. But the same day, we also talked about this case, Gilmore versus Georgia Department of Corrections, about a suspicionless strip search in a jail, I believe, and there was a qualified immunity involved. Anyway, that case, which we had some harsh words for, has gone to en banc at the 11th Circuit, and it's currently in briefing. So stay tuned on that one. Now, another recent episode, we talked about dicta in the Ninth Circuit and how the Ninth Circuit, I said, this is like the only common law jurisdiction anywhere where dicta can actually be controlling. I think it has to be like well researched dicta or whatever the Ninth Circuit calls it, which is an odd quirk out there. But then Joe said, Joe, he was one of the very few of you listeners out there, and he listened to the show and he said, you know what? That's not quite true, because we also have that in Wisconsin. And I think I had learned that a few years ago and forgotten about it. So Joe, remind me, how is dicta law in Wisconsin?
So in Wisconsin, the rule is relatively similar to what it is in the Ninth Circuit. This came from a 2010 Wisconsin Supreme Court case called Zarder v. Humana Insurance Company, in which the Supreme Court of Wisconsin said that Wisconsin courts of appeals, the intermediate court, cannot disregard a statement in a Supreme Court opinion as mere dicta. So the result, right, is that Wisconsin courts of appeals are often hamstrung by sometimes, off the cuff or less than reasoned statements in the high court's opinions, and that has led to many folks being frustrated, including justices on the Supreme Court more recently who have written some separate opinions questioning the rule and advocating for its demise.
And that sounds broader even than the Ninth Circuit, because it's not like it has to be well reasoned, whatever that means. It's just anything a majority opinion says.
There's been some rather oblique language in the decade and a half since that has tried to differentiate between what constitutes binding dicta and non-binding dicta, but even so, that it leaves a lot of gray area, and oftentimes the Court of Appeals will simply say, look, we can't do anything about this because we're worried about what the Supreme Court will say. So,
and then at the Court of Appeals level, you reminded me, which is, I think, true in some other states too, that even though there are Court of Appeals districts, if one Court of Appeals has a published opinion and has an actual ruling, that is then binding on the other Court of Appeals circuits?
That's correct. When the state created its intermediate appellate court system back in the 70s, part of those statutes included a rule that said any published opinion is statewide binding precedent. So that's set by statute. Yeah. But the courts have since interpreted that to also mean that the Court of Appeals cannot overrule itself. So in order for a bad or wrong or outdated precedent of the Court of Appeals to be overruled, it has to get accepted and overturned by the Supreme Court.
That, I guess, one result of that, I mean, you could argue whether that's a good idea or not. One result of that is there is a lot more, quote, law in the Wisconsin courts than otherwise, because you have dicta from the Supreme Court, and then you have a ruling from, a Court of Appeals circuit you're not even, or whatever you call it, you're not even in, and thus you have a lot more of holdings to draw from than say, the equivalent under the federal system. Do you think that's true?
I think that's one way to look at it. Probably the flip side is you might have less organic law development because you don't have disagreements between the districts, and therefore the Supreme Court doesn't always have a good understanding of what the disputed issues really are, whereas you have circuit splits right in the federal system.
Yeah. So, which kind of leads into the other point you made about the Wisconsin Supreme Court is not exactly been robust with its voice lately.
So that's a charitable way to put it. In the 90s and 2000s, the Supreme Court of Wisconsin was hearing up to 100 cases per term.
Which is pretty normal for a state Supreme Court, I think. That kind of number.
And then it reduced to 50, 60 cases per term in the past 5 to 10 years. Last term, it only decided 14 cases. This term looks like it'll decide more, but still not its historical output.
You wonder what the judges and the clerks even do all day if they only have 14 opinions a year. Well, we won't speculate too much on why that is, but who knows? Maybe it's a harbinger of what's going on at the U.S. Supreme Court, because they're on a similar trajectory, although haven't quite got to those levels yet. But enough with the state courts. This is short circuit, and we have one of the biggest circuit court cases you can think of, which is an en banc decision. And it's a quite split en banc decision from my old stomping grounds of the Seventh Circuit. So, Joe, tell us about your case and how you're trying to, you went en banc and are now trying to go even higher.
Absolutely. The case is called Gilbank v. Wood County Department of Human Services. And it is about the Rooker-Feldman doctrine. And because when I was in law school, Rooker-Feldman was just a footnote, I think I'll start by giving a brief background on what Rooker-Feldman is, or at least purports to be. So it's a doctrine of federal subject matter jurisdiction that gets deployed in tens of thousands of lower court opinions every couple of decades at least. It derives from constitutional and statutory text. Article 3 of the Constitution creates the Supreme Court and authorizes Congress to create lower courts. Right? And with that power, as we all know, Congress has done a couple of things. First, it's given the Supreme Court appellate jurisdiction over state court decisions raising federal issues. It has also created lower federal district courts and appeals courts. But unlike with the Supreme Court, it has not authorized those lower federal courts to hear appeals from state court decisions. So there's a common sense rule that emerges from that framework, which is that lower federal courts lack subject matter jurisdiction to hear appeals from state court judgments. And there are two cases from the 1900s, one called Rooker and one called Feldman, in which the Supreme Court iterated and reiterated that principle. But here comes the problem. After 1983 in the Feldman decision, lower courts began using that doctrine more and more to dismiss cases. And although it said it was dismissing them for subject matter jurisdiction under the Rooker-Feldman doctrine, the reasoning often looked like preclusion analysis, abstention, comity, prudence, things like that. Then in 2005, the Supreme Court stepped in a case called ExxonMobil v. Saudi Basic to try and cabin the doctrine and say it's limited to when a few things are present, including a request to review and reject the state court decision. In the 2 decades since then, since 2005, more confusion has arisen in the lower federal courts, to say the least, prompting Judge Sutton Chief Judge Sutton of the Sixth Circuit to recently write that Rooker-Feldman is, quote, back to its old tricks of interfering with efforts to vindicate federal rights and misleading federal courts into thinking they have no jurisdiction over cases Congress empowered them to decide. So the question that has really emerged, and that comes to the fore in our case, the case that I'll talk about in just a second, is if Rooker-Feldman bars lower courts from exercising appellate jurisdiction over state court judgments, what does it mean to invoke appellate jurisdiction? Everyone agrees that the federal plaintiff must have lost in state court, must be raising some claim of error, and that the state court judgment caused that plaintiff some kind of injury. The dispute is whether those three elements, loss, error, and injury, are both necessary and sufficient or just necessary, and whether or not there's another element that has to be present. Namely,
Oh, I'm sorry. But Joe, I just maybe a clarifying question, especially for non-lawyer listeners. So is one way to think about it is if you go to state court, you lose, and then you were to file a notice of appeal in the state appellate court and say, basically, I want you to reverse what this lower court did. But instead of doing that, you basically have the same paperwork and you file it as a lawsuit in federal court. Everyone agrees that is covered by Rooker-Feldman. And it's how close it is to looking like a state appellate, triad appellate reversal that it's going to be covered.
That's exactly right.
But there's all this gray area, right?
There's all this gray area. And the case that you just described is the Rooker case, really. Mm-hmm. Somebody had a state court judgment against them, and then they went to a federal district court and said, I'm appealing this. Please reverse this state court judgment. And everybody agrees that that is a violation of Rooker-Feldman and that the lower federal court has no jurisdiction to hear that case.
Right.
The question is whether or not you have to ask for some kind of what I'll refer to as appellate relief. Do you have to ask the lower federal court to change the state court judgment in some way? So we'll see how this operates in our Gilbank case. Michelle Gilbank, who's our client, she's a mother of 3 daughters, 2 of whom are now adults, and the third, we'll refer to by her initials, TEH, is a much younger young adult now. But at the time, she was a young child at the time of these events. In 2018, a child welfare agency, the Wood County Department of Human Services, removed Gilbank's youngest daughter from her custody, and then a state court entered a custody order placing the daughter with her biological father, who was also a convicted sex offender. Gilbank was eventually reunited with her daughter, and they remain together today. But after getting her daughter back, Gilbank, on her own, pro se, brought a Section 1983 civil rights lawsuit in federal court, and she only asked for damages, money damages. And she said the police detective and the social workers involved in the removal and custody proceedings violated her constitutional rights. And the officials, she has maintained ever since, failed to notify her of hearings, depriving her of procedural due process, submitted false statements to the state court, and otherwise interfered with her substantive due process rights to raise her family as she saw fit. Now, the district court dismissed Gilbank's claims under the Rooker-Feldman doctrine. And it said because a finding in this case would contradict the state court's findings, it lacked subject matter jurisdiction. After that decision, Gilbank, again still on her own, appealed to the Seventh Circuit. And at this point, the Seventh Circuit recruited me and my colleagues at Hush Blackwell to represent her. And on appeal, we argued 2 main things. First, that Gilbank was not actually complaining of injuries that the state court custody order was responsible for. Instead, she was complaining of injuries that the police detective and the social workers inflicted upon her. And the mere fact that a state court proceeding also took place didn't trigger Rooker-Feldman.
Right.
And then second, and completely separately, we argued that Gilbank was not seeking the, quote, review and rejection that the Supreme Court's ExxonMobil case demands. Because in federal court, she was only seeking damages as a remedy, whereas the state court only decided custody and placement of her child. And so even if she were to recover damages in federal court, nothing about the underlying state court order would be changed at all. And so because of that, she's not invoking appellate jurisdiction as the law would understand that term. February 2023, I argued this to a panel, Judges Kirsch, Hamilton, and Pryor. August 2023, we get an order from the court. I see it come through on Pacer. I figure it's an opinion. It's actually a sua sponte order saying that the court has decided to rehear the case en banc. And then in February 2024, I argued the case en banc to what at the time was an 11-judge Seventh Circuit.
And what is it up to 12 now? Or what's the latest?
It's either
on the
11
7?
or 12. There were 10 active members plus Judge Hamilton, who was a senior judge, but he was part of the original panel. And by circuit rule, if you're a senior judge, but you're part of the original panel, you also sit on the en banc court for that case.
So here's a very short circuit question. I have seen Seventh Circuit arguments. I have argued a couple myself in the federal building in Chicago with 3 judges. Is the en banc courtroom like the floor above that, or like what's it like in there?
It's actually, surprisingly, the floor below that. The bigger ceremonial courtroom, they call it, is, I can't remember the numbers now. It's either 25 and 26 or 26 and 27, right? So yes, there's a courtroom below that they use for en banc arguments.
And it's got all 12 chairs there in front of you.
Indeed.
Is that your only en banc argument? I've never done it. We've only had a couple at IJ over the years. Our colleague Jabba had one at Fifth Circuit a few months ago, but I would think it's a little intimidating, even compared to the circuit court argument.
Yeah, that was my only en banc argument, and in all likelihood, the most judges that I'll argue in front of for a long time, right? So we get the outcome on, I think, August 1st of this year. And I say the outcome because I have to describe it in parts. If you read this opinion, it's 80 pages, and it is extremely difficult to understand exactly what happened. The bottom line is that the court affirmed the dismissal of our client's claims in their entirety. The decision there, the judgment, was 6 versus 5. There was 3 opinions, and there was no majority reasoning in support of that judgment. So to break it down, we've got 5 judges to start with. Judge Hamilton writing, Rovner, Brenner, Jackson Akawumi, and Pryor joining. And they held that the Rooker-Feldman doctrine does apply and bars Gilbank's claims. And in their words, the Rooker-Feldman doctrine calls for a, quote, practical approach. They analyzed and they said that, look, Gilbank lost in state court. She's arguing about things that happened as a result of that state court order, injuries she suffered as a result. And because she's bringing that grievance to court, she's necessarily seeking review and rejection, because to redress her injury would require us to disagree with the state court. So for that group, it's enough to say a federal court that disagrees with the state court triggers Rooker-Feldman. That's only slightly reductive.
Mm-hmm.
Then we have a second opinion concurring in the judgment from Judge Easterbrook. And he creates that bare majority of 6 judges. He says, I don't think Rooker-Feldman bars jurisdiction here, but the case should be dismissed anyway. Why? Because of Heck v. Humphrey's favorable termination rule. Here's the wrinkle. Nobody briefed Heck. No other judge agreed with Heck. And it's hard
That's
to
never
see
stopped Judge Easterbrook before.
It has not. It's hard to see how Heck v. Humphrey has a place here. This is not a case involving a criminal conviction. It's not a case involving the length of a sentence or anything to do with criminal process. Even Judge Easterbrook's own opinion acknowledges that he's extending Heck to a place it really has not gone before. No matter, he says, because, quote, there is just no point to a remand in this case. Now, there are 5 judges who would have reversed and remanded. And that's Judge Kirsch writing, joined by Chief Judge Sykes, Scudder, St. Eve, and Lee. Now, they have a more formalistic understanding of the Rooker-Feldman doctrine, and a much narrower one. They start from the premise that Rooker-Feldman bars a federal court from exercising appellate jurisdiction. And they go through an analysis of what appellate jurisdiction means. whether we're in the Rooker-Feldman context or not, a claim of legal error isn't enough to invoke appellate jurisdiction. Instead, somebody asking for appellate jurisdiction, no matter where they are, has to be asking that court to do something to an existing judgment. Reverse it, vacate it, modify it, change it, whatever words you want to use, but do something of the kind that an appellate court does. So you have to compare the relief, they say, that the state court granted or denied to the relief requested in federal court. And once you do that, this case is an easy one because the state court only adjudicated custody, and the only thing Ms. Gilbank asks for in federal court is damages. They say, look, even if Gilbank is arguing that the state court got something wrong, that's a question of state preclusion law, not federal subject matter jurisdiction. Now, as frustrating for us as this decision was, all of the judges dropped some great nuggets for a cert petition. And the one that I like the most came at the beginning of the opinion, in which they said, all members of the en banc court agree there is a, quote, need for the Supreme Court to clarify application of the Rooker-Feldman doctrine. And so
that's pretty good.
That's pretty good. And we've taken them up on that offer. We have a cert petition pending. We highlight a circuit split in the question that the Seventh Circuit judges divided on. On the one side, there's the Ninth and 10th Circuits. And on the other side, joining the Kirsch view, the formalistic view of Rooker-Feldman, is the 11th Circuit and the 6th Circuit, actually based on an IJ case, Hohenberg v. Shelby County. And then the other circuits are confused. They take varying, vague approaches to Rooker-Feldman that don't fit into either bucket really easily, but nevertheless raise questions. We highlight the importance of the issue. Again, it comes up in thousands of cases. It's important for civil rights claimants who want to plead their federal claims in federal court. And it raises federalism issues. On the one hand, ensuring that the federal courts don't step on state courts' toes seems commensurate with federalism. On the other hand, if they go too far, Judge Newsom of the 11th Circuit has pointed out how that actually risks federalizing state preclusion law. We've also highlighted everything wrong with the prevailing Rooker-Feldman rule in the 7th Circuit and the other circuits that agree with it, including that it ignores text and precedent, and it converts the test to a mere preclusion test. So that's where we're at. We have a couple of amicus briefs that we're expecting, and then a response will be filed in January. The respondents received an extension, and presumably a conference date sometime early in 2025.
Well, a lot going on there. Arif, you have spoken about Rooker-Feldman on this very podcast before. So your thoughts?
There is a lot going on in the case. Thanks, Joe. And ExxonMobil seemed to have laid out a pretty clear rule. It was a unanimous opinion written by Justice Ginsburg. But in the 6th Circuit case, IJ's case, that we got up and got a reversal after Rooker-Feldman deprived our clients of their day in court, Judge Sutton correctly described it as this is an exceedingly narrow, quote unquote, limitation on the jurisdiction of district courts. There are many, many, many types of lawsuits that this discrete limit on jurisdiction does not cover. It's not claim preclusion. It's not issue preclusion. It's not preclusion by another name. But yet here we are. And in that particular case, in the 6th Circuit case, which is a good case, I'm glad that we got a nice reversal and Judge Sutton wrote that decision. You had two homeowners who, for reasons such as letting grass grow and another client, a tree branch falling on their roof, did not maintain their houses up to the standards that neighbors and the homeowners associations thought necessary. And they were sued in an environmental court. It's not a real court. No rules of procedure, no rules of evidence, no records kept. This is not a real court. violates due process, especially when you end up depriving people of their homes. And that's what happened. Both clients were subject to arrest. One was for not complying with orders of this, quote, court, this environmental court. And both found themselves without a home. The homes were destroyed, and then they sued in federal court. And then the government argued that all you're trying to do here is attack the underlying state court judgment. And it's important because in the Sixth Circuit case, there was no judgment. This environmental court, which follows no types of procedure or rules of evidence, just kind of closed out the cases, dismissed them without entering a judgment.
They just kind of do things until you give up, if I remember right.
Right. But this has actual real-world effects on real people. Now, fortunately for both clients in the Hodenberg v. Shelby County case in the Sixth Circuit, IJ took up that case from the very beginning. And so, there were resources there to litigate. But you can see how Rooker-Feldman, if misapplied, can run roughshod over people who maybe will take the first crack and try to get a remedy in federal court. But then, don't have the resources to litigate just obvious misapplications of a doctrine when they're just seeking to vindicate their federal constitutional rights in a federal forum. Like Joe said, this is happening everywhere, all over the country. You've got tons of cases since ExxonMobil. And so I think the time there's no more percolating necessary. You've got open invitations by en banc Seventh Circuit decisions. You've got people's rights being deprived in real, meaningful ways that deprive them of justice. And, this is the type of thing that the Supreme Court, should correct course on. I mean, it's obviously having widespread negative impacts on people's rights and the ability to access a tribunal where they can vindicate them.
Yeah, Joe, you don't just have a split, you have a banana split. I mean, a lot of appellate attorneys would just kill for the circuit saying different things from what the Seventh Circuit said that you just have laid out in your cert petition. So I think if this is not granted, it will not be for want of a split. Perhaps for other things we can speculate about if that happens, but we hope it doesn't. Listeners can go to Short Circuit 275, and I'll put a link in the show notes for that. When Arif talked about this Sixth Circuit case from Judge Sutton. Joe, I had one question here. What it seems to me, knowing much less about this area than you do, is that courts instinctively think about this in terms of like res judicata, and they think of Rooker-Feldman as being kind of another way to do res judicata. And for listeners' benefit, basically that means you do a case and you lose, and you could have, whether the claims you actually brought or claims you could have brought but didn't, you don't get a second bite at the apple. And so then if you go to federal court, it's kind of, think about it as an appeal, but think about it more like, well, you didn't bring those other claims, but you could have, and now you're trying to bring them again, so I'm going to shut you down. But of course, as is pointed out in the en banc dissent, that's not the same thing. That the res judicata has different rules. Sometimes you can have something that's res judicata and is not Rooker-Feldman, or even vice versa. But you can't confuse the two, because then you're going to get people who actually aren't covered by res judicata. And so that's not why they get thrown out, but they get thrown out for Rooker-Feldman, even though it's really res judicata.
That's right. I mean, that's what the analysis ultimately often comes down to, is a preclusion analysis, whether it be res judicata and claim preclusion or its cousin issue preclusion. Even though the court is saying we're doing a Rooker-Feldman analysis, that's really the tools and the language they're employing is more of preclusion. And there are huge problems with doing that, because Rooker-Feldman is a federal rule. Preclusion rules, even if they're deployed by a federal court, are all state law. And they often are different state by state, even if just on the margins. And they often have equitable exceptions that take into account things like fairness. Mm-hmm. And a jurisdictional dismissal is without prejudice, but a dismissal for preclusion, again, depending on state law sometimes, is oftentimes a judgment on the merits with prejudice. So those are just a few of the reasons why it's important to keep those doctrines.
And in your client's case, I mean, it's not like she filed a lawsuit in state court, brought damages, could have brought other stuff, whatever. It's that she was involved in a custody proceeding that she didn't bring. And now later she's just trying to bring her own civil rights lawsuit.
That's exactly right. It was the state who initiated proceedings against her.
Right.
And, another thing that we don't really talk about at this point in the case, but that we briefed earlier, was how much the statutory framework that applies in a custody proceeding limits your ability to raise certain defenses and the time you have to raise certain defenses. Totally different than a Section 1983 action in federal court, where you have the ability to raise all of your claims, seek all of your remedies, and do discovery, all of that kind of thing, which is severely cramped in a children's court proceeding in state court.
Right.
And rightfully so. Look, we want kids to be safe, and we want them to be in the right place at the right time. And so it's appropriate to have a condensed proceeding. But that shouldn't prevent her from vindicating her rights when government officials have done something.
Yeah. I mean, an extreme way of putting it maybe is that you can't have a state statutory scheme for dealing with a discrete problem like that with child custody, nullifying Congress's desires in Section 1983 in the 1871 Civil Rights Act. It really is kind of bizarre.
Huge part of that. Huge part of it. Absolutely.
Well, we are going to move from child custody proceedings now to a different kind of state court, and that is when someone gets arrested. Sometimes other people want to be there, including members of the press, to see what the court is talking about when people are arrested. But there's a part of Texas, Arif, where they didn't like those nosy reporters getting into their courtrooms. So what's going on there?
So we're going to talk about Caldwell County, Texas. Let me start by saying something good about Caldwell County. It's half hour south of Austin, and right smack in the middle is Lockhart, Texas, one of the barbecue meccas of Texas. So if you come to Austin, it's worth just renting a car for the day and spending that day in Lockhart. You'll never regret it. In fact, one of our colleagues went all the way down to Lockhart to get married because of the barbecue. That's Caldwell County, and I respect their barbecue game. They can smoke brisket like no one else in Texas. But Caldwell County, Texas, along with 5 magistrate judges there, justices of the peace, and the sheriff, cobbled together a policy of fencing out the public and the press from magistration hearings. What's a magistration hearings? It's what takes place at the very beginning of a criminal proceeding. And you'd want maximum transparency there. You want to have open government and transparency peaking, I think, when you've got the exercise of the police power directly intersecting the liberty interest to such an extent that this person's already being detained or in a cage and jailed. And what happens here, these are bail hearings. State law in Texas, reflecting Due Process 101, requires that if you're arresting someone, the person making the arrest or whoever has custody of the person that was arrested has to, without unnecessary delay, and certainly no later than 48 hours after the arrest, has to bring that person before a magistrate of the county where the arrest took place. And under state law, the magistrate judge is tasked with informing the accused of what they're arrested for, what the charges are, informing the accused of what their constitutional rights are that they're entitled to. And the judge is also instructed under state law to admit the arrested person to bail if allowed by law. Important stuff going on here. But Caldwell magistrations were closed to the press and to the public pursuant to this policy that was put together by these judges and enforced by the sheriff. And so a lawsuit gets filed. And the lawsuit gets filed by the Texas Tribune, which is a nonprofit and news organization in Texas, published online and does a lot of coverage in Austin of the state legislature, but also beyond Austin throughout the state, does a lot of great reporting and are committed to transparency and open government and open records and public information and open meetings. And here, open courts. So they sue along with a local nonprofit paper there, the Caldwell-Hayes newspaper, The Examiner, and a nonprofit org called Mano Amiga, who helps people with bail. They each have a nonprofit mission. They exist to advance that mission, and their mission is to either report or provide transparency, inform the public, or assist people subject to these proceedings. But they are fenced out. So they sue, and they bring a preliminary injunction immediately in federal court. They sue for violations of the 14th Amendment and of the First Amendment. The district court enters a preliminary injunction. So for the non-lawyers out there, a preliminary injunction is an extraordinary remedy. It effectively is the court saying, okay, I'm going to give you the relief that you need because we need to protect your rights. You're likely to prevail. You have a substantial likelihood of prevailing on your claim. And here the preliminary injunction was based on the First Amendment claim. There's irreparable injury that will occur, but for entry of an injunction early on in the case, not after discovery and after a summary judgment on a full record, that the balance of harms are squarely in your favor, that entering an injunction will protect you, but will not, and that outweighs that interest, whatever the government claims harm will befall the public, and that it's in the public interest. Now, these are the different elements that courts consider. Here, the substantial likelihood of prevailing on the merits was the key linchpin to the PI, and it's what bubbles up here to the Fifth Circuit, because the county didn't like this preliminary injunction, so they wanted to appeal. And they bring two different arguments on appeal. One is an argument rooted in jurisdiction. They're saying that there is no standing. The Texas Tribune, the Hayes Examiner, the Caldwell-Hayes Examiner, and Mano Amiga just don't have standing to sue. And the second argument they bring addresses directly the First Amendment question, and that there's no substantial likelihood of prevailing on the First Amendment claim, and reversal is required. Now, this is two different standards of review that are at play. Whether they're standing or not is a question that appellate courts review de novo. But reviewing whether there's a substantial likelihood of prevailing on the merits is reviewed for abuse of discretion. And the panel here, interesting panel actually, it was before Judges Wilson, Douglas, and by designation, District Court Judge Vitter. And Wendy Vitter, Judge Vitter writes the opinion. And it's well-written, well-reasoned, and I recommend it to folks. And whether you're a lawyer or not, you can follow along quite well. And if you're a student, you'll learn about standing, about preliminary injunctions, and about the First Amendment. And so let's touch standing first, because I mean, what's going on here is that these news organizations, these nonprofits have a mission, and their ability to advance that mission is being stifled by being deprived access to judicial proceedings. And here we have pretrial proceedings. And the court just jumps right into it. And it's not going to go well when the court goes out of its way to cast the county's position on standing as, quote, not particularly clear. So, Judge Vitter says, although the county's position on standing is not particularly clear, it appears to argue that these news orgs just have not suffered an injury in fact because the plain language of the statute, the Texas Code of Criminal Procedure that governs magistration hearings, does have requirements, but does not require open magistrations. So it seems like they're taking the view that the scope of your right here to see a pretrial proceeding should be governed by the outer contours of state law. Now, I think Judge Vitter, the panel correctly points to the county's confusion that this is a merits-based analysis that you're advancing here, which looks at the litigant's claims, but not a standing analysis, which considers whether you're entitled to have a court decide the merits of the dispute. And so the court immediately turns to injury in fact, and that's really the only area of the standing analysis that the counties take issue with, not causation or redressability, but whether there's an injury. And the court, logically looks at Texas Tribune and what they do, and they regularly report on a broad range of criminal justice issues, including bail and pretrial detention in the criminal justice system. The local news outlet, the Caldwell-Hayes Examiner, reports on issues relevant to Caldwell County, their criminal system. And Mano Amiga helps people put up bail and wants access to these magistration hearings to help people bail out. And so it's clear, at least to the Fifth Circuit panel, that each of these organizations is injured by being denied access to magistration hearings and bail setting. And they rely on a U.S. Supreme Court case that kind of concludes why a nonprofit would have the ability to rely on the stifling of its mission as a basis to have standing to challenge the deprivation. And they quote Havens Realty Corp v. Coleman, a 1982 case, where the Supreme Court said the following, quote, "Put differently, the perceptible impairment to an organization's ability to carry out its mission, not the drain of the organization's resources, is the concrete and demonstrable injury for organizational standing." And that's great. So they have standing. The court also finds that there's causation, that the reason they're deprived is due to this policy, and that there's redressability because if it's enjoined instantly, you can participate in these proceedings. The court notes that there is no fight over those two prongs, but they're satisfied. So the court moves on to the First Amendment issue, the substantial likelihood of success on the merits on the First Amendment claim, and opens up by pointing to Richmond Newspapers v. Virginia. It's a 1980 case where the U.S. Supreme Court held that the right to attend criminal trials is implicit in the guarantees of the First Amendment. And then later, 6 years later, in a case called Press Enterprises Co. v. Superior Court of California for Riverside County, the Supreme Court then later finds that the First Amendment question cannot be resolved solely on the label that we give an event. So if the government decides to call something not trial and something else, that label is not determinative of whether the First Amendment right to access pretrial proceedings attaches. The court also looks at sister circuits, and other circuits have gone on to find that the First Amendment's right of access is not just confined to trial, but also extends to additional criminal pretrial proceedings, including suppression hearings, due process and entrapment hearings, hearings at which a criminal defendant pleads guilty. And so it's a broad right to access a proceeding where the government is bringing someone they've arrested before a neutral tribunal. And so a policy that would deprive access to that implicates the First Amendment, and courts have sided with the side of challengers that want to exercise their First Amendment rights. Now, there's a test. Now, this is not so this arrives at the Fifth Circuit, but it's not the first time that the Fifth Circuit has addressed this type of challenge. And before I jump into that, what governs the analysis here, whether a particular proceeding falls within the First Amendment's protections, is governed by a two-factor test called the experience and prong test. The experience prong looks at whether the place and the process have historically been open to the press and the public. The logic prong considers whether public access plays a significant positive role in the functioning of the particular process in question. And so with that as the backdrop, the Fifth Circuit then turns to an earlier case that they've had to wrestle with that kind of illustrates how this works. And this is a 1983 case called United States v. Chagra. And if the name sounds familiar to some listeners in Texas, this is the case that involved an El Paso attorney, Joseph Chagra, who's charged with the murder of a district court judge. This was Judge John H. Wood, Jr. And in that case, there was a bail reduction hearing, and there was a deprivation of access to view it. That bubbles up to the Fifth Circuit. That's where you get United States v. Chagra. And there, the court looked at both the experience prong and the logic prong and said, look, we addressed the history in that case of open bail hearings and the societal interests that are related to pretrial hearings. And the court found that while bail reduction hearings don't have this unbroken, uncontradicted history of public trials with access to the public, it doesn't foreclose access to bail reduction hearings because the importance of pretrial procedures has grown to that of a trial in the past 200 years. I think you can see that. Just if you take a step back from the criminal justice system, there's very few trials, but there's a lot of stacking charges. There's a lot of coercive plea bargaining. There's the misuse and frankly offensive use of mandatory minimums to coerce people into giving up their right to trial. And all this has withered away the Sixth Amendment to a shell of itself. And the court can and should return it to its proper place in our constitutional architecture.
Yeah, you can be in court a lot and yet not have a trial. But you'd still like people to be able to see you there in court.
That's right. And so the Fifth Circuit correctly recognized in the early 80s that things are a lot different. And what goes on in the early part of a case is extremely important. And there's also a logical component of this. There's a positive societal interest in having open pretrial hearings because you want to have increased public confidence in what's not just confidence, but an understanding of the judicial system. And if it's closed, if you're not seeing how it operates, if you're not reading about what's going on there, there's an erosion of those two things. And so in this particular case, in Texas Tribune v. Caldwell County, both sides argue that Chagra bolsters their respective positions. You've got the organizations saying, look, although Chagra concerned bail reduction hearings, its analysis is nevertheless instructive of whether there's a First Amendment right with the magistration. I mean, that's where you're setting bail in the first instance. The county, for its part, points to language in Chagra that says, quote, while the public and press may request access to bail hearings held in court or other places that traditionally are open to the public, nothing in the opinion should be construed as forbidding the more informal bail proceedings discussed in the 1982 Chagra case. Now, the Fifth Circuit is not persuaded by that. They note at the outset that Chagra pointed, the Chagra language that's invoked by the county is dicta, to bring dicta back into the discussion. And it's not binding on their decision. But regardless, magistrations are just far from informal proceedings. In the life of a case, as I mentioned earlier, this is the pivotal point that combines the Fourth Amendment's required probable cause determination with the setting of bail. And it's also the point where the arrestee is formally apprised by a neutral arbiter what they're being accused of and what their rights are. And so the county, could have chosen in the past to conduct magistrations informally or attach a label to them, but that is not dispositive of whether the First Amendment right attaches. And then the court goes into the history of open pretrial proceedings in general. Notes that for over 200 years, you have almost a near uniform practice of state and federal courts conducting preliminary hearings in open court. Historically, if you look even deeper on a more specific level, both historically and currently, there's a practice of open bail proceedings. In 1554, per Judge Vitter and the panel, Parliament required that bail bond decisions be made in open session, that both justices be present, and that evidence that was weighed be recorded in writing, in public, and open. And on our side of the Atlantic, just in the wake of the Revolutionary War in the early 19th century, Aaron Burr's treason trial suggests that bail proceedings were open to the press and the public during the founding era. And so you have, evidence that these types of proceedings have enjoyed at least some level of openness. And if you look at how things fit in today in the way that criminal proceedings are conducted, bail hearings just fit comfortably within the sphere of adversarial proceedings closely related to trial. So the Fifth Circuit panel takes a look at all of this together and says, history satisfies the experience prong. It then turns to the logic factor, which quite logically, lands on where you'd want, what you'd want from a judiciary that's trying to adjudicate a criminal matter. And there, the same societal interests present in Chagra with bail reduction are present here. You want, if you have private proceedings, there's a risk that, yes, you can avoid criticism, but then you can proceed informally and less carefully. But if you allow public access, you encourage adequate preparation by the jurist and precision by the court, in addition to increasing confidence and understanding judicial procedures and the court system. So the court finds that both the logic prong and also the experience prong have been satisfied, and upholds the entry of the preliminary injunction and affirms. And of course, you have language like the right is not absolute. There may be instances where you can close a proceeding, But the policy that you had in Caldwell County, where there was not even an opportunity to be heard if there was going to be a completely closed proceeding, and frankly, their blanket policy of depriving people access, the public or the press, didn't stand a chance here. And frankly, it shouldn't. And I think it shouldn't because that's where you want maximum transparency and open government. There are plenty of examples, even in other IJ cases, where you see the government excluding clients, for example, from a press conference because they're not the right, quote, media. Well, that's not law enforcement's job to decide who or what. In fact, you should want more transparency. Or you see examples like our case in challenging Bexar County's traffic stop patterns violating the Fourth Amendment. You sue in federal court, their immediate move was to block every reporter from having access from the video of any types of traffic stops at all, not just the one being sued over, under the Open Records Act. They don't have to, but they're invoking exceptions. The instinct is almost a shield, not to open up the blinds of transparency. And here, tip of the hat to the Texas Tribune for taking the fight to federal court, ensuring the First Amendment is one that we can all enjoy, not just in Caldwell County, but elsewhere when someone is accused of a crime. And another tip of the hat to who litigated this case, public interest lawyers at the Knight First Amendment Institute, who took up this case and argued it in the Fifth Circuit and won. And it has been a very lot of action at the institute at Columbia University there, both because they had a big win in this case, but it also comes on the heels of a very sad event, and we should mourn the loss of Ted Olson, who was on their board for several years. And so, the fight continues. I think everyone should be happy of the result in the Fifth Circuit, and law enforcement should take note. Transparency is your friend. It's exactly what people expect from their government, and it's what the First Amendment guarantees, especially when the government's exercising its extreme broad powers, especially in this context.
Absolutely, and thanks for mentioning Ted Olson, Arif. He was someone that many people, all of us, have come across in our careers, touched deeply, and everyone has great things to say about him, whatever their politics. So that's good for us to mention. Joe, have you ever been to a bail hearing?
That's a great question. I may have gone to a few in law school, but I certainly have never represented anybody at a bail hearing. I read this Texas Tribune Caldwell County case, and I certainly think that it reached the right result. The one thing that perhaps tripped me up a little bit in the analysis was this experience and logic test. I had never heard that before in a First Amendment analysis. On the one hand, it reminds me a bit of the history and tradition test that the Supreme Court has used in its recent Second Amendment jurisprudence, in the Bruin case and in the Rahimi case. But of course, the experience and logic test here looks like it certainly predates those cases and really has nothing to do with it, even if the possibly malleable application of it is similar. And I also wonder if, even though we go through that analysis in each case like this, where we're talking about public access to the courts, if the rule we're creating or that has been created really isn't a relatively bright line one where any proceeding before a charge is presumptively closed, like a grand jury hearing, right? And any proceeding after a charge or an arrest is presumptively open. And then in individual cases, for instance, because of particularly sensitive materials or what have you, there might be a reason to close that particular case or that particular hearing, but the burden would be on the person seeking to close it, not the person seeking to open it. I guess one other relatively trivial point from the opinion, I noticed that District Judge Vitter, who wrote the opinion, uses footnotes for all of her legal citations, and I wondered if Arif, you maybe had any thoughts on that practice. I'm not a fan personally.
Well, she's taken that from her Fifth Circuit colleague, Judge Willett, I'm guessing, who is a massive fan of that, and I am also not a fan, Joe. So we're aligned there. Arif, any strong thoughts on that?
I've long mined some of the footnotes from different judges because I think there's great stuff buried in there. But whether I take no position, I'd have to give it more thought. I think I'll leave it there. It's I can see the from a readability standpoint having to look down just that aspect of it. If you're not used to it, you need to get used to it. And I kind of like seeing the citations in the body of the text as well. But that's a nit. I think as long as opinions come out like this, where they're judicially engaged, where they're trying to pursue the genuine, or engage in a genuine pursuit of the truth on the basis of actual facts and law and explain themselves and not just rubber stamping what the government wants, like you see sometimes in Rooker-Feldman, just bending the doctrine. I can deal with the footnotes. When you get a bad decision, like a crappy Rooker-Feldman decision that just pours out your clients, I would be much more bothered by it. So I think for me, where I fall on the citations depends on the level of judicial engagement. And I want engaged jurists all the time. And I like your point about that test does ring like history and tradition. But notice also that it also takes the common sense approach of seeing like where we're at today and tying it back historically. Criminal prosecutions today very different than what took place a couple hundred years ago. The role of the jury in the trial was a robust bulwark against abuse of government power. And with that gone, the abuse takes place, and it takes place early before a trial. And here the court correctly recognized that was the case. And so I think history can be useful if we look at history and tradition, but it can also be easily misused. You can just blind yourself and defer to the government by ignoring large swaths of the history. If history and tradition are going to be guides to the original public meaning of text, then reflexive deference to political branches should play zero role in original public meaning analysis. And that's not what we're dealing with here, but you can see here how the Fifth Circuit back in the early 80s and then now are looking at criminal trials and criminal proceedings with clear eyes and not through a jaundiced lens that perhaps a government official like those that came up with this policy in Caldwell County would view the proceeding.
And I wonder if that points to one thing that I was wondering in reading it, because I don't often read cases on open courts, open trials, that kind of thing, is it's a little funny that it's a First Amendment right. Like I get from the newspaper's perspective, this is our right to report on these events. And I know that there are these cases from kind of the Warren Court, Bergen Court era about grounding a First Amendment right in open courts and the freedom of the press to be involved in there. And I'm very supportive of that understanding, but I wonder if it's kind of more feels like a due process right, or even, dare I say, a privilege or immunity of citizenship to have open courts, right? There's lots of state constitutions that have explicit open court clauses, and this understanding, as the history in the opinion shows, goes way back. But that's kind of a different thing from a freedom of the press right type of right. And you could have both. I'm not saying you can't have both, but I wonder if that way of looking at it kind of is more makes the history make sense. That this is just to have due process, you can't have closed courts, right? Democracy dies in darkness, or what have you. That really is grounded in this ancient tradition that probably goes back to Magna Carta. If we took a look at it, or something like that. So I wonder if that maybe would round it out a little differently. But the case law is the case law, and I get what the newspapers are doing here.
I agree. I think you can see this from different lenses, and how it would affect people's rights. I mean, just look at it from why we have juries. We have juries because the government's going to government, and so the founders correctly viewed juries as a bulwark against that kind of abusive exercise of power. You can see the importance of juries looking back to William Penn's trial in common law England days, where the jury was. I mean, there were some jurors with backbone there, trying to, they were being almost forced to rule against Penn. And so it does provide a measure of transparency and buffer between the police power and the individual who's accused. If you remove trials completely, where are the people that are provide that? I mean, these are citizens that are selected to sit on a jury. So here you'd want to have citizens there just to view the proceedings. It just acts as you just have eyes. It just that's the opening of the blinds of transparency, and we can couch it in all sorts of lenses from due process or other rights. But at the end of the day, it's about relying on citizens to ensure that the government is not exceeding, the confines of its power against an individual. And but I do agree, this is a government-created forum. So in a case that we're litigating against Fort Bend, Texas, right outside of Houston, they deprived our client, Justin Pulliam, of going to a press conference because he was in the right press. He was a citizen reporter who used YouTube to comment and scrutinize public meetings and then also take video and report on law enforcement. And he won. He just won summary judgment on that claim, no qualified immunity. And that's exactly right. But case after case, you're almost seeing the reflexive approach from law enforcement to shield, to close, to prevent transparency. And it just backfires because to what end? What do you want to hide from the public? You're doing the public's work, apparently, protect and serve. You're using the public's resources. The cameras that you wear are provided by the public. And so you should want to be transparent. And I think those that do take that approach end up with a much better system in place because there's more trust and there's more access. And hopefully Caldwell County can elevate their game. It won't be as good as the barbecue game in Caldwell County, but at least let's get better than depriving the public from pretrial hearings.
Well, we'll look forward to better courts in Caldwell County. And we're also going to look forward to open federal claims in the Seventh Circuit. So we'll keep our eyes on Joe's case as it percolates at 1 First Street in Washington, D.C. So good luck, Joe, with the cert petition. Thank you for coming on and discussing the case. Thank you, Arif, for your barbecue tips and First Amendment exploration. And thank you all for listening. Please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.